Good morning, everyone. I'm Ed Uvoli. I'm an ACU board member. I'm also a tax attorney, so you know this is going to be a very fun presentation. Today we're going to hear from three terrific speakers on private property, or more particularly, our rights to property. Why property rights? Well, part of the mission of this conference is to review our fundamental principles as conservatives. These principles, or natural rights in this case, must necessarily inform our policy preferences just as they informed our founders when they wrote our Constitution. So the next three speakers will be talking to you about three forms of private property: real property or real estate, personal property like paintings or pickup trucks, and intellectual property like Apple's Apple or Coke's formula. What's happened to our rights, our natural rights, to property like this? What has our government done or tried to do to take our property rights away from us? How have foreign countries tried to do the same? These speakers will explore these topics. So let's now welcome our first speaker, the Attorney General of the state of Nevada, Adam Laxalt, to discuss real property. And he's also a new board member of the ACU. So welcome to Attorney General Laxalt.
Good morning, everybody. How we doing? And for you fellow West Coasters, it's still only 6 a.m., so thanks for getting up and getting motivated. I'm truly honored to be here. My grandfather, Senator Paul Laxalt, was a founding board member of the ACU. And for him to come in the 80s with President Reagan and all those great conservatives, they were able to start our movement, and for the ACU to continue this legacy, it's just a great honor to be here this many decades later. All right, the Fifth Amendment, Takings Clause. Most of you know what that is. The government shall not take private property for public use without just compensation. I would argue that respect for private property is a bedrock conservative principle. We agree? Indeed, if you go back to the founders, this is a bedrock American principle. And I don't think anything gets conservatives more riled up than a really bad takings case. So that's what I'm going to do today. I'm going to talk about one old case and one brand new case. Most of you have heard of the now infamous Kelo case. This was a case from 2005 in the city of New London in Connecticut. And in that case, the city council voted to take private property, in this case, Mrs. Kelo's little pink house, and a bunch of other people's private property so they could give it to another private corporation for economic development. Yes, boo. The Supreme Court, in a highly contentious 5-4 decision, cited this very precise viewpoint on how you can arrive on what is a public use. They said, diverse and always evolving needs of society. We're always leery of when the Supreme Court uses the word evolving, right? Further, they said the government needs broad latitude in determining what the public needs justify the use of this power. An incredible decision, an incredible extension of takings law, and something that really riled up people all across the country. That's the bad news. What was the good news? There was an unprecedented, what I call Kelo backlash. First, the city council eventually issued a public apology to Mrs. Kelo for bulldozing her little pink house. Second, public was enraged all across the country. Every time people heard that they took someone's house and gave it to another private corporation to develop, people were, instinctively revolted that this must go too far. So what did that result in? 45 states rushed, either through ballot initiatives or through their legislature, to restrict takings law. This is a great, great result coming out of Kelo. And legal scholars, at least on our side, would say it did something incredibly important. It broke this march towards this view that the government had unlimited power to take your land for any purpose. I want to add the kicker of the Kelo case. That was in 2005. All of this property lies vacant today. They bulldozed all these people's homes, and the development fell through, and nothing was ever built. I think that shows the hubris of government. It shows the hubris that we conservatives continue to fight, that whether it's the Supreme Court or other government, that they don't always know what's best for the American people. So now I'm going to move into our most recent case, and that is the Murr case, which will be in front of the United States Supreme Court in less than a month. The Murr family bought a lakefront property in Wisconsin in the 1960s. They built a house, great place. A few years later, they bought an adjacent property. Flash forward to the 2000s, they decided they wanted to sell this adjacent property. And because of an unknown regulatory law that was put in place in the 70s, they were told they could not sell this property. The government wasn't willing to compensate them as a taking because they argued that, well, you have 0% of this property, but you have 100% of the property next door. And they're starting this new concept that you can add the two properties together, and as long as you have some use in the combined properties, then it's not a taking. We argued, the state of Nevada and many other states across the country, in an amicus to the Supreme Court, that this is truly an unprecedented reach for takings in public use. Specifically, we argue that, one, takings law and what is public use is already invented. The Supreme Court has already had to just kind of try to divine what this is as we go. Second, for those of you that have small businesses, know that you may have your shop on one parcel, you may have a garage or other things on another parcel. To act like these are all the same thing for eminent domain is really a shocking extension. Wisconsin has been successful at making this argument. We're encouraged that the Supreme Court has taken this case because we hope that they're going to draw a new line to say that you can't take 100% of someone's property and simply put it with another one and act like that's not a taking. So our biggest argument, and I'm going to channel Justice Scalia here, would be the following. The Founding Fathers didn't say, you shall not take private property for public use without just compensation unless they own property next door, in which case it's cool. You can take their property. They've got a nice little lakefront property anyway. What's it to you? Enjoy your property. Don't worry about your property next door. We argue that this is an unprecedented reach. We encourage
logos. So let's all welcome Professor Adam Mossoff. He's an ACU Foundation Fellow, and he is currently at the Antonin Scalia Law School at George Mason University. Professor Mossoff.
Good morning. I'm here to talk to you about something extremely important, although a lot of people aren't aware of it because it underlies a lot of the goods and services that we use today, and that's intellectual property. And intellectual property is under attack, both domestically and internationally. And this is really important to understand why, but a lot of people don't do so because they don't understand the foundations of where intellectual property has come from and its key role in the United States and in American exceptionalism. You see, the founders created a republican government dedicated to the protection of life, liberty, and property under the rule of law. And this included the very important key protection of intellectual property. And so the American founders were not just political entrepreneurs who broke from England and our broader structure and nature of our government. They were also entrepreneurs in recognizing that creators and innovators should have the fruits of their labors protected to them, just as farmers and tradesmen historically have had theirs protected under the law. Thus, in the Constitution, for the very first time in human history, a founding document creating a government authorized that government to protect patents, which are property rights in technological innovation, and copyrights, which are property rights in new creative works like songs and movies and books. And in fact, Congress immediately acted on this. The founders recognized how important this was. And so some of the very first laws enacted by the first Congress in 1790 were the Patent Act and the Copyright Act of 1790. And thus, securing the intellectual property rights to all creators and innovators, it became a foundation for driving the Industrial Revolution in this country in the 19th century. Many people don't realize Samuel Colt's repeating firearm, the foundation of our Second Amendment protections, was a patented invention. So was Samuel Morse's telegraph, John Deere's plow, Charles Goodyear's invention of vulcanized rubber, Thomas Edison's light bulb, his invention of the record player, of our electrical distribution systems, our ability to use electricity. And thousands of other innovations arose from the protection of the rights of innovators in our country, confirming for the whole world that America was not just a beacon of liberty and freedom, it was a beacon of innovation and creativity, the true shining city on the hill. And thus, in the 20th century, protection of intellectual property drove the high-tech and biotech revolutions that we're all enjoying the benefits of from today. So the work of Bill Gates, Steve Jobs, scientists and researchers working in their garages and universities in the 1970s is what gives us our miracle cures and our incredible high-tech technologies today. And this is confirmed again and again how important this is. A recent study by the Department of Commerce found that companies that rely on intellectual property rights in their business models contributed more than $6 trillion to the US economy in 2014 and were responsible for 45 million jobs that year. 30% of all the jobs in the United States are based in intellectual property. President Abraham Lincoln, our first Republican president, wisely recognized this important principle when he said himself, quote, "The patent system added the fuel of interest to the fire of genius," end quote. And by the way, President Lincoln knew of which he spoke. To this day, he's the only US president to have received a patent on an invention that he created. Now, this is the foundation by which we need to understand the attacks on intellectual property today that are occurring both internationally and domestically. Now, domestically, like all property rights, like you just heard, are under attack in the United States, and intellectual property rights are under attack as well. It's become nearly impossible to obtain a patent in recent years on new high-tech innovation and biotech inventions that provide us these miracle cures, our smartphones, as I mentioned, our medical treatments for cancer and other things. And so the US is in danger of losing its long-standing status as a world leader in innovation. Internationally, US innovators are under attack in other countries, like China and South Korea, who use their antitrust laws to target US companies and inventors for the sole benefit of protecting their own domestic companies and their own consumers. And these countries repeatedly fail to crack down on rampant piracy of creative works on the internet. Now, what makes this even worse is these countries have rationalized their attacks on U.S. innovators and creators by pointing to the very changes in the laws here in the United States that have weakened these protections. And to make matters even worse, the Obama administration repeatedly refused to defend U.S. innovators and creators when China and other countries attacked their rights. So U.S. competitiveness in the global economy is now threatened because our very rights of our own creators and innovators, the foundation of our innovation economy for over 250 years, has been seriously weakened and undermined. And this is so, I urge you to support wholeheartedly intellectual property rights across the range. They are key. They are just as fundamental as our property rights in our land and our personal goods. In a recent letter to the Trump administration and the 115th Congress, over 70 organizations and individuals, including the ACU, wrote, quote, "The founding fathers understood that by protecting the proprietary rights of artists, authors, entrepreneurs, innovators, and inventors, they were promoting the greater public welfare. The continued protection of these fundamental rights is essential to American innovation and competitiveness," end quote. So we should reclaim America's rightful leadership by securing stable and effective intellectual property rights for all innovators and creators. Thank you.
Okay, is this too many lawyers for you? Let's change pace and bring on the Chief of Police of Lindsay, Oklahoma, Stephen Mills. He's going to discuss our rights to personal property. Chief.
I want to thank Ed for the introduction. What he didn't say is I'm really just an old soldier. I'm a cattle rancher. I wear this uniform because I've been given and I accepted a position of responsibility for my fellow citizens. I intend to live up to that position of responsibility. I'm here to talk about asset forfeiture reform. There's various government and non-government agencies out there that are proponents for continuing civil asset forfeiture in its current form. Often these people will give you a scenario that there's a state trooper out on the highway somewhere and he sees a speeder coming. He stops the individual, searches the vehicle, and finds $400,000 all heat sealed and hidden up in the fenders of the vehicle, and they say that's cartel money. And then without civil asset forfeiture, the only thing that this trooper can do is write that individual a ticket and give the cartel their money back and send them down the road. I'm telling you, that's not how it is. That's not the reality of civil asset forfeiture. Here's the reality of civil asset forfeiture. The majority of forfeitures are less than $10,000. They aren't taken from hidden compartments in cars, and they aren't cartel drug money. An actual civil asset forfeiture is more like this. Your local octarian artist, we'll call her Grandma Moses, she just sold 10 paintings at the local flea market. She's got a few $1,000s hidden under the seat of her vehicle as she leaves. There's a local officer who's got legitimate information that drug dealers are also selling drugs at that local flea market. So he's watching as people leave the flea market, and he stops Grandma Moses and he talks to her and he says, "Hey, do you mind if I can search your vehicle?" And Grandma Moses, she loves the police. She's been grown up to respect the police. She knows that we're out there to protect her. She says, "Sure." The officer finds the $10,000 and he seizes it under civil asset forfeiture as drug money. Grandma Moses says, "Well, wait a second, that's my money. I've got it selling paintings." The officer says, "Prove it. Prove that it's not drug money and you can have it back." She doesn't know what to do. She calls the local prosecutor and gets the same story. The prosecutor says, "Yes, under civil asset forfeiture law, you have to prove that you're not the criminal. You have to prove that that's not drug money to get your money back." She calls the sheriff's department. The sheriff's department tells her the same thing. She keeps complaining and they finally tell her, "Look, you need to stop calling us and complaining, or we're going to look at you real hard. You want us to prove that you're a criminal? We're going to look at you real hard and we're going to prove you're a criminal. Now she really doesn't know what to do, because the last time they looked at her, they took her $10,000. So she stops complaining. They got her way. But do you think she really has that same respect for the police department and for the officers? Do you think she still trusts them to protect her? No, that's exactly right. No is the correct answer. How do I know this is the real reality of civil asset forfeiture? Well, I saw it firsthand, and it happened to me. I was a CID agent in Texas. I was running a counter-drug task force. We didn't conduct civil asset forfeitures, but we worked with other local agencies that did conduct forfeitures. After an arrest of a low-level drug dealer out in front of his grandmother's house, we were walking to this other agency. They were carrying the grandmother's television and furniture and all their household items out of the house. My partner asked the officers, "What are you doing?" And they said, "Well, she has to prove that she did not know what her grandson was doing, and she has to prove that she paid for this through legitimate money, and then she can have it back." And my partner, he looked at me and goes, "That doesn't seem right, does it?" And I said, "No," and we left. We couldn't stop it, but we didn't have to be a part of it. I also own a cattle ranch in Oklahoma. While I was assigned to this task force in Texas, my wife was home running the cattle ranch, and we had hired hands working for us. One of those hired hands was out running an errand, and he saw a spool of copper wire at a soon-to-be oil field site, and he stole that copper wire. Local citizens saw him do it and called the sheriff, as they should have. Sheriff came up and arrested him, as they should have. Stealing is wrong regardless of who does it. The problem was, when they arrested him, they also took my truck. Now, I just assumed that they seized my truck as evidence, and I called the sheriff's department. I said, "Hey, when are you going to be done with my truck?" And I was told, "We're not going to be done with it. You're not getting your truck back. We're taking that as under the civil asset forfeiture laws." I said, "Well, you can't do that. I'm an innocent owner. The law says that I'm an innocent owner." And they told me, "Well, prove you didn't know he was going to do that." I mean, think about that for a second. How do you prove that you don't know something? I mean, it's easy to prove you know something. You say what you know. But how do you prove that you don't know something? And that's what they were asking the citizen to do to get their rightful property back, was prove that they did not know something. Not under civil asset forfeiture. I didn't let it go. And after about 6 months, I did get my truck back. But it was an uphill fight the whole way. The average citizen wouldn't have had the knowledge, the tenacity, or the resources that I had, being who I was, to get my truck back and win that fight. I was a federal law enforcement agent, and they were calling me a dirty cop. They were threatening me with criminal charges and treating me like a criminal, all because I was fighting for my rights and trying to get my property back. What makes it worse is there's even actual classes out there teaching police officers to treat people like this, to get them to shut up and go away. Even elected legislators fighting for asset forfeiture reform are treated like this. My friend Senator Kyle Loveless in Oklahoma has been trying to get a measure on to the Oklahoma legislator for 2 sessions now. Can't even get out of committee. He's being called a terrorist, ISIS, Al-Qaeda, and worse, for trying to effect a change. How strong can your position be if you won't even let it come up for debate? The primary function of police and judicial system is to protect the citizens. The police, we protect the citizen from the criminals, and the judicial system is there to protect the accused. It's not the best system, but it's the best system in the world. When the police and judicial system become the antagonists and no longer protect the rights of the accused, we have failed the greater mission of protecting the rights of the citizen. We have created innocent victims. Currently, the standard of proof to seize an individual's property is preponderance of evidence. I actually have to get more proof to get a warrant than I do to seize somebody's property. If the investigation stops at the side of the road after the property is seized, how are you going to get this evidence? You're not going to get any evidence of innocence. If you don't investigate the crime, you have an assumption of a crime. You don't have evidence of a crime. How do we fix this? One, the burden of proof needs to be put back on the government as constitutionally intended. It means the police are going to have to start investigating the assumed crime, not just taking the property and moving down the road. If $400,000 an offender is evidence of a crime and should be taken, then it's evidence of a crime. Investigate the crime. We as police officers need to do our job, protecting the rights of the citizens. We can't serve the citizen while simultaneously depriving them of their natural and constitutional rights. One innocent victim is one too many and does way more damage than letting the criminal get away. President Trump, I want to thank your administration for your support of law enforcement. After the last 8 years, it's a wonderful and welcome change. I know you're being told by other members of law enforcement and associated groups that asset forfeiture reform is a bad idea, that it'll help the cartels and terrorists. I want you to know that there's many of us out in the field who don't agree with that sentiment. As law enforcement officers, we can't step on the rights of the citizens we are sworn to protect under the guise of protecting them. This country was founded of the people, by the people, and for the people with certain inalienable rights. That is what made this country strong, and that is what will make this country strong again. Thank you.
Okay, I think you've heard our speakers say fairly loudly and clearly, and let me put this in technical legal terms, stop taking our stuff. Let's face it, the lefts, including the last administration, didn't like private property. They didn't believe in it. You recall you didn't build that, which in short really means that's not yours. So they've been slowly boiling the frog and taking away property rights bit by bit. For homes, eminent domain and judges have expanded that term, eminent domain, to really allow the government to take anything for public use, which has been so broadly defined. So they've literally taken the homes of little old ladies to give it to other people. For intellectual property laws, have gotten so eroded by the courts and our own laws, by Congress, that it makes it difficult for companies and people to own and, yes, profit. And profit's really not a bad word. Is this the only place where profit's not a bad word? From their work and their efforts. And this erosion has opened the door not only to problems here in the U.S., but to the taking of our property by other countries. And finally, with respect to personal property, you've seen how criminal laws have been turned upside down, how the burden of proof has come upon citizens to prove their innocence with respect to things they had nothing to do with. Even the police chief's own pickup truck was taken away from him. Crazy. So what should we be doing about it? What should we be thinking about it? Well, we have to remember always how fundamental our property rights are. We have to understand and recognize the problem and understand every day that this is something we got to think about and do something for. We've got to encourage our legislature and our president to pass laws to protect our property rights. We've got to have judges appointed who understand the importance of these rights and their fundamental nature in our Constitution. And we've, of course, got to enter agreements with other countries which protect these rights of our own citizens. So thank you. Let's work together as a nation, and let's make sure that we don't let other people take our stuff. Thanks very much.